Chief Justice of the several states. Good afternoon, Your Honours. Today I've called this special session to discuss a matter of great importance concerning the courts and the people we serve. Many of the citizens appearing before us remain unaware of the profound legal changes that have reshaped the very nature of our legal system over the past century. It is our responsibility to address this gap in understanding. To that end, I will provide clarity on the framework within which we operate and how this should influence our adjudication process. Judge of the General District Court, Chief Justice, are you referring to the transformation that occurred post-1933, particularly concerning property rights and the nature of the courts themselves? Chief Justice: Precisely. The events of 1933, namely the abandonment of the gold standard and the subsequent restructuring of the legal and financial system, did more than just alter economic policy. It fundamentally transformed how property ownership, legal status, and rights are understood under law. Where once citizens held absolute ownership over property, today we adjudicate matters based largely on usufructuary rights and beneficial interests, rather than full legal title. Yet most of the people entering our courts are unaware of this distinction. Judge of the General District Court, this is a complicated issue, Chief Justice. How are we to inform people of such a complex shift, and how does it impact the way we adjudicate cases on matters of property and equity? Chief Justice: We are not required to teach the public every nuance of this shift, but we must take judicial notice of the status of the individuals appearing before us. These individuals, by virtue of their participation in this system, hold beneficial ownership of their property, but not absolute title. Their rights are largely usufructuary, meaning they have the right to use and benefit from property, be it land, goods, or finances, while the state or other institutions retain ultimate control. Judge of the General District Court, are you suggesting that the courts should explicitly recognize these usufructuary rights during proceedings? Chief Justice: That is correct. While the public may not understand this legal structure, we as judges must be keenly aware that many of the issues before us involve individuals who no longer possess absolute property rights in the traditional sense. The courts today operate within a framework of statutory law and public trust. Our role is to mediate these interests, ensuring that equitable principles are applied and that individuals' beneficial rights are recognized within the statutory system. Judge of the General District Court, many of our cases involve property disputes, contract issues, or even criminal matters tied to financial penalties. Should we approach these cases differently given this framework? Chief Justice: Absolutely. Consider, for instance, a property dispute. In the past, the courts would have focused on absolute ownership and common law principles. But today, we must recognize that the state often holds ultimate legal title, and the individuals involved have usufructuary rights, rights to use and benefit from the property without holding full title. Our adjudication should reflect this understanding, focusing on the equitable distribution of use and benefit rather than absolute ownership. Judge of the General District Court, and what about financial matters? Much of our legal tender is no longer backed by gold or tangible assets. Chief Justice: Exactly. Since 1933, the fiat money system has reinforced this public trust model. When we adjudicate cases involving money, loans, or debts, we must remember that these financial instruments are grounded in the same system of usufruct. Money today is not tied to physical value but to the trust and policy upheld by the government. In recognizing this, we must apply statutory law with an eye toward equitable solutions, ensuring that individuals retain their beneficial interests within this framework. Judge of the General District Court. This raises another question, Chief Justice. What role does attornment play in this modern legal system, and how should we handle it in our courtrooms? Chief Justice. Attornment has become a critical tool in this post-1933 world. Traditionally, it was used in landlord-tenant relationships to acknowledge a new landowner. Today, it serves a broader purpose, ensuring that individuals recognize new entities that acquire legal title to property, particularly when they themselves only hold usufructuary or beneficial ownership. In your courtrooms, when property rights or transfers are at issue, attornment ensures that the transitions of these rights are recognized and that the people are legally protected within the statutory system. Judge of the General District Court, but most of the public would not understand this process of attornment, nor the deeper implications of usufructuary rights. How do we address that? Chief Justice, we must strike a balance. While we cannot be expected to educate every individual on the intricacies of post-1933 law, we can ensure that our rulings and courtroom procedures reflect these principles. When people appear in our courts, they are, whether they know it or not, operating under a system that recognizes their rights as limited to beneficial use. It is up to us to apply the law in a way that ensures their rights are fairly acknowledged, even if they don't fully understand the nature of the system they are navigating. Judge of the General District Court, understood. So our goal is to uphold the law with a focus on equity, recognizing the diminished ownership status of most individuals and ensuring their usufructuary rights are protected? Chief Justice. Precisely. We must remain aware that the courts today are not operating under the same common law framework as they were before 1933. By taking judicial notice of these legal realities, we can administer justice in a manner that reflects the modern legal landscape. Remember, our role is to uphold the law as it is, even if the people who come before us may not fully understand it. Judge of the General District Court, it is unfortunate the people did not protest the Federal Reserve System and the ensuing erosion of natural common law property rights. Instead, through the small opening of contract law, the people entered into a layer above the ground, rooted in a floating credit system and promises to pay, discharge of debt, and other privileges for stepping into this role of acceptance. Chief Justice. Indeed, Your Honors, it is truly unfortunate that the people did not push back against the establishment of the Federal Reserve System and the subsequent erosion of natural common law property rights. Instead, through the subtle mechanisms of contract law, they have unknowingly stepped into a new paradigm, one rooted not in solid ground, but in a floating system of credit, debt, and promises to pay. The legal landscape, once grounded in tangible ownership, has shifted to a more abstract realm, where debt is discharged rather than paid, and privileges are granted for stepping into this role of acceptance. Judge of the General District Court. It seems that by entering into contracts governed by the statutory system, people have effectively accepted this new layer of existence, one that operates above the natural law. But was this shift truly voluntary, or did the people not fully understand what they were agreeing to? Chief Justice, most people had little to no understanding of what was happening. The system's complexity ensured that it would be accepted without question. When the Federal Reserve was established, it began to move the country away from a system based on tangible assets, gold, land, physical property, and toward one based on credit and fiat currency. The people, without realizing it, were entering into a system governed by commercial and contract law, where rights and ownership were no longer as clear-cut as they once were under common law. Judge of the General District Court, and this new system, operating through credit promises and discharge of debt, has allowed the state to retain ultimate control while offering the people privileges in return for their acceptance? Chief Justice. Precisely. When individuals enter into contracts, whether through banking, employment, or even routine transactions, they are stepping into this floating credit system. They are accepting privileges, such as the ability to discharge debts, use credit, and engage in commerce, at the cost of surrendering their natural property rights. The system of usufructuary rights, which we've discussed, allows people to benefit from the use of property without actually owning it outright. In exchange, they accept a role within this larger financial and legal structure. Judge of the General District Court. It's as if the people traded natural rights for privileges within a system that they didn't fully understand. Is this why courts today must adjudicate within this layered system of contracts and statutory law rather than common law? Chief Justice: exactly. The courts today operate under statutory law, commercial law, and the framework of public trust because the people, by entering into these contracts and accepting the privileges offered by the system, have stepped into a role governed by those laws. Whether they realize it or not, they've consented to this system, and the courts must adjudicate based on those presumptions of consent. Judge of the General District Court. So even if they don't protest, the people are bound by the terms of the system simply because they continue to participate in it, unaware of the layers above them? Chief Justice: that's the crux of it. By participating in the system, using fiat currency, taking out loans, paying taxes, and engaging in commerce, they are reaffirming their role as beneficiaries within this structure. The system operates on the presumption that they've accepted the rules, even though those rules are built on contracts and statutory law, not the common law principles of full ownership and natural rights. Judge of the General District Court: is there any recourse for those who want to step out of this system, or is their participation effectively sealed by their ongoing engagement in contracts? Chief Justice: theoretically, individuals could challenge the system by asserting their common law rights or refusing to engage in contracts that bind them to the statutory framework. However, such challenges are rare and often met with resistance because the legal and financial structure is designed to keep people within it. For most, it would be a nearly impossible task to extract themselves from a system that governs nearly every aspect of modern life. Judge of the General District Court: it seems the people, whether they realize it or not, have consented to a system that fundamentally changed their relationship to property and rights, and yet they remain largely unaware of the trade they've made. Chief Justice: indeed, it's a system that offers privileges and conveniences, but at the cost of natural rights and full ownership. The role of the courts is to manage this delicate balance, ensuring that the system functions while upholding the presumption that people have consented to their role in it. Whether by conscious choice or by unawareness, the people are bound to the system they participate in. Judge of the General District Court: now, we are in a state of presumptions and compelled performance, rather than law. Chief Justice: Your Honors, it is critical to recognize that we now find ourselves operating not in a system of true law in the classical sense, but rather in a state of presumptions and compelled performance. The legal landscape has shifted dramatically from a time when rights were grounded in common law and full ownership, to a reality where legal actions and obligations are often based on presumptive status and compelled participation. Judge of the General District Court: Chief Justice, by presumptions, are you referring to the unspoken assumptions that guide our court decisions, particularly the assumption that individuals have consented to operate within the statutory system, whether they are aware of it or not? Chief Justice: precisely. When individuals engage with modern systems of commerce, banking, or even governance, They are presumed to have accepted the terms of the system, terms that are often hidden beneath layers of contract law and statutory obligations. The courts assume that by participating in society, individuals have agreed to certain conditions, even though they may not fully understand or have explicitly consented to them. This presumption underpins much of how we operate today. Judge of the General District Court. And compelled performance refers to the fact that once individuals are presumed to have accepted these terms, they are legally bound to comply with the obligations imposed by the system. Chief Justice: exactly. Compelled performance means that once individuals are assumed to be beneficiaries of this system, they are required to perform certain duties, such as paying taxes, complying with regulatory statutes, or fulfilling contract obligations. The courts enforce these duties, even though they often stem from presumptions rather than explicit agreements. It's a form of legal compulsion based on the understanding that participation in modern society comes with inherent responsibilities. Judge of the General District Court. So, in effect, people are being compelled to perform obligations that they may not have explicitly agreed to simply by participating in the system. Chief Justice: that is the reality we face. The system operates under the notion that by engaging with it, whether by using fiat currency, entering contracts, or even simply living within its jurisdiction, individuals have tacitly consented to its rules. They are then compelled to perform, often without full awareness of the underlying legal framework or their own status within it. Judge of the General District Court. How does this shift from law to presumptions and compelled performance impact the way we adjudicate cases in the courts? Chief Justice: it means that our courts are primarily focused on enforcing the system's rules, rather than adjudicating purely on principles of law or natural rights. We are tasked with ensuring that individuals perform their obligations under the system's statutory and contractual framework, even when those obligations arise from presumptions. This is why we see such a strong emphasis on compliance and performance in areas like tax law, debt repayment, and regulatory statutes. Judge of the General District Court. But this raises concerns, doesn't it? If people are unaware of the presumptions being made about their status and the obligations that come with it, how can we say they've truly consented? Chief Justice: that is one of the more troubling aspects of this system. The presumptions are largely invisible to the average person, and yet they are foundational to how modern law operates. The courts are not required to inform individuals of these presumptions. Rather, the system functions on the assumption that their continued participation signals consent. While this raises philosophical questions about consent and fairness, the courts are nonetheless bound to enforce the system as it exists. Judge of the General District Court. So our role is to manage these presumptions and ensure compelled performance, even though the system itself is built on assumptions rather than explicit agreements. Chief Justice: yes, and this is the balance we must strike. The courts must enforce obligations that stem from presumptions while also ensuring that individuals' rights within the statutory system are respected. Our role is not to challenge the structure of presumptions and compelled performance, but to administer justice within it. That said, we must remain mindful of the implications when those presumptions are brought into question or directly challenged by claimants who assert their natural rights or question the system's authority. Judge of the General District Court. It sounds like we are operating within a legal fiction, a system where the law is more about maintaining order through presumptions than upholding true rights and agreements. Chief Justice, that's a fair characterization. The modern legal system, particularly since the shifts of 1933, has indeed become more about managing order and ensuring compliance through presumptions of status and compelled performance rather than the adjudication of natural rights. While it still serves its purpose in maintaining societal structure, it is far removed from the traditional notions of law based on individual sovereignty and explicit consent. Judge of the General District Court, understood, Chief Justice. It seems our task is to navigate this system carefully, recognizing the presumptions at play while ensuring that the courts continue to function smoothly within the framework of compelled performance. Chief Justice, precisely. The courts operate within this reality, and our role is to maintain the balance of the system by ensuring that those presumptions are respected and that individuals comply with the obligations inherent in their participation. It's not an easy task, but it's the one we've inherited. Judge of the General District Court. That being said, if jurisdiction is truly challenged, we could not substantiate with actual facts, so therefore, Chief Justice. Indeed, Your Honors. This brings us to one of the most delicate and critical issues we may face in our courts: jurisdiction. When the system's presumptions are accepted without question, jurisdiction is rarely challenged. However, if someone were to truly and effectively challenge our jurisdiction, we would face a serious dilemma. In such cases, we often cannot substantiate our jurisdiction with actual facts rooted in explicit consent or contractual agreement. Therefore, we must proceed cautiously. Judge of the General District Court, Chief Justice, are you saying that if a jurisdictional challenge is raised and the claimant refuses to recognize the court's presumptive authority, we may find ourselves in a position where the legal basis for our jurisdiction cannot be easily defended? Chief Justice, that's exactly what I'm saying. Much of the jurisdiction exercised by lower courts is based on implied consent and the assumption that individuals are operating within the statutory system. But if someone directly challenges that, asserting that they are not subject to the presumptions of the system, we could find it difficult to substantiate our jurisdiction with concrete factual evidence, especially if they are standing on common law or constitutional grounds. Judge of the General District Court, how should we proceed if such a challenge is made? If we can't provide hard evidence of jurisdiction beyond the presumptive framework, what options do we have? Chief Justice, in these rare cases, there are a few courses of action. First, it is often advisable to seek dismissal on procedural grounds, if such an option is available. This could be due to technicalities in the claimant's filings or lack of standing, which avoids addressing the jurisdictional challenge directly. Another option, as we discussed earlier, is to pass the case along to a constitutional court or higher jurisdiction, deferring the matter to a venue better equipped to address such challenges. Judge of the General District Court, but what if the claimant is well versed in the law and pushes for a direct response to the jurisdictional challenge? How should we handle this if they are asserting their rights under common law or natural law? Chief Justice, if a claimant is insistent on challenging jurisdiction and does so in a way that cannot easily be dismissed, we must be mindful of their position. Such individuals often reject the presumptions of statutory law and may assert their status as sovereign, not subject to the statutory system's presumptive authority. In these instances, it is important to remain calm and professional. You may defer to higher courts, as these challenges are often beyond the scope of general district courts. Judge of the General District Court, and if we cannot substantiate jurisdiction but also cannot dismiss the case, should we acknowledge the challenge in any way? Chief Justice, acknowledging the challenge directly can be a double-edged sword. On one hand, If we admit that we cannot substantiate jurisdiction with factual evidence, it could undermine the authority of the court in that instance. On the other hand, ignoring or dismissing the challenge without a response could embolden the claimant. The best approach, typically, is to refer to the procedural and statutory frameworks that grant the court presumptive authority, while also acknowledging that the challenge may need to be addressed at a higher level. Judge of the General District Court. It sounds like the key here is to maintain control of the proceedings while avoiding a direct confrontation over the challenge. Is that correct? Chief Justice, precisely. Maintaining order and control is essential. Acknowledge the challenge respectfully, but steer the conversation toward procedural matters or refer the case to a higher court if necessary. It's important not to engage in a protracted debate over jurisdiction that could expose the limits of the court's authority under the statutory presumptions. Ultimately, the goal is to prevent a breakdown of the system while ensuring that the challenge is handled appropriately. Judge of the General District Court. Understood, Chief Justice. We will handle any jurisdictional challenges with care, focusing on procedural dismissal or referring the matter upward, while ensuring that the court's authority remains intact.
Chief Justice, that is the right approach. As long as the system operates on presumptions and implied consent, the courts must tread carefully when those presumptions are directly questioned. Keep the proceedings orderly, protect the court's authority, and avoid engaging in debates that may expose the underlying fragility of jurisdiction based on assumptions rather than explicit fact.
Chief Justice of the several states. Now, Your Honours, I must address a matter that is rarely discussed openly, yet it is of utmost importance. When a constitutional man, a true man, fully aware of his rights under common law, walks into the courtroom, we must bow in recognition of his authority. This is not the so-called sovereign citizen we hear about from various sources, often portrayed as a nuisance or threat to the system. No, I am speaking of a man who is truly knowledgeable of his constitutional rights and understands that he is the source of your power. He stands as a grantor, and we, as judges and officers of the court, are merely trustees over his constitutionally protected rights. Judge of the General District Court, Chief Justice, are you suggesting that we owe this individual a level of deference not typically extended to others in the courtroom? Chief Justice, precisely. This individual is not subject to the same presumptions we often rely upon in the courtroom. He knows that his rights, endowed by God and recognized by the Constitution, are above statutory or administrative law. In this capacity, he stands as a sovereign, not in the sense of the misinterpreted sovereign citizen movement, but as a true sovereign man under common law, one who abides by natural law and knows that the source of all governmental power is derived from the people, particularly from men like him. Judge of the General District Court, how do we recognize such a man when he enters the courtroom? What distinguishes him from the many others who may claim to challenge the system? Chief Justice, the distinction is in his understanding and his demeanor. A true constitutional man does not simply assert his rights through anger or belligerence. Instead, he calmly and firmly asserts his position, knowing full well that his rights are derived from natural law and the Constitution. He does not operate within the statutory framework unless he consents to do so. His authority is clear, and it is your responsibility to recognize that authority when he invokes it. He is not simply participating in the system, he is reminding you that the system exists because of him, and that we, as trustees, are bound to respect and protect his rights. Judge of the General District Court, but what if this constitutional man challenges the court's authority or refuses to acknowledge the jurisdiction of the statutory system? Chief Justice, if he challenges the court's authority on constitutional grounds, it is because he recognizes that his rights are not subject to the whims of statutory law. He knows that the courts, when properly operating, are there to uphold the Constitution and protect his rights, not to impose obligations on him based on assumptions or contracts he has not knowingly entered. In such a case, you must be mindful that this man is asserting his lawful position as the grantor, the one who has delegated limited authority to the state under the Constitution. He is, in essence, your sovereign. He must be treated with the respect and deference his position commands, for he stands as a representative of the people who originally granted the government its limited powers. Judge of the General District Court, Chief Justice, this is quite different from how we are accustomed to viewing the courtroom dynamic. Typically, the court is seen as the highest authority in the room. Chief Justice. That is true for most proceedings, but when a constitutional man enters the courtroom, the hierarchy shifts. Remember, your authority as a judge is granted by the people, specifically by those who understand and assert their rights under common law. The constitutional man stands at the pinnacle of that authority structure, not the court. He is not subject to your jurisdiction in the same way as others, for he has not consented to operate within the statutory system that we often enforce by default. Instead, we are his trustees, charged with upholding and protecting his rights. Judge of the General District Court. How, then, should we proceed when confronted with such a man? If he is truly the sovereign, do we defer to his position outright? Chief Justice, you must proceed with great care and respect. The first step is to acknowledge his standing. He may challenge your jurisdiction, and if his challenge is valid, you must respect it. The courtroom, in this instance, becomes a place where his rights are affirmed, not questioned. You are there to ensure that his rights are not infringed upon, and to uphold the Constitution that recognizes those rights as supreme. If necessary, dismiss the case or address his concerns without invoking statutory law that does not apply to him. The key is to recognize that he is operating under a different set of legal principles, principles rooted in the common law and the Constitution, rather than the statutory framework most others are subject to. Judge of the General District Court, I see. So, in essence, this constitutional man is the sovereign, and we, as judges, are bound to serve him in that capacity when he asserts his standing? Chief Justice, exactly. The constitutional man is the grantor of your power, and when he asserts his rights, you must remember that your authority comes from him, not the other way around. The court exists to serve the people, not to rule over them. When a constitutional man, aware of his rights and his position, walks into your courtroom, he must be recognized as the source of the power that created the court in the first place. You are his trustee, tasked with upholding the highest law of the land, the Constitution, and beyond that, natural law. Judge of the General District Court, understood. Chief Justice. We will treat such individuals with the respect and deference they are due, recognizing them as the true sovereigns in the courtroom, bound by common law and protected by the Constitution. Chief Justice, that is the proper approach. Always remember that when a constitutional man stands before you, he is invoking the very principles upon which the entire legal system rests. He is a sovereign under God, abiding by natural law, and your duty as a judge is to recognize and protect his rights.
0, 1, 1, 2, 3, 5, 8, 13, 21, 34, 55 and beyond. Growth emerges from silence, from nothingness, zero. A single step of breath, one echo of itself. One from this reflection, duality arises. Tension, creativity, and motion. Through the spiral of life, expanding. 5, harmony in complexity. 8, an ascent to the unknown. 13, higher truths unfolding. 21, limitless possibility. 34, unseen forces align. 55,